On October 11, 2024, Daniel McGuff was arrested for assaulting, resisting, or obstructing a police officer, a felony under Section 750.81d of the Michigan compiled laws. He was arraigned the same day, chose to represent himself, and was released on a $5,000 personal recognizance bond. The court set a probable cause conference for October 24, 2024. In Michigan, a probable cause conference is an early hearing in felony cases that takes place after arraignment but before the preliminary examination. It gives the prosecutor and defendant a chance to discuss possible plea deals, share evidence, and address bond or other procedural issues. Before the scheduled conference, on October 20, 2024, Mr. McGuff sent a motion titled Motion for Discovery, Subpoenas, Suppression, and Other Relief related to the incident of October 11, 2024, to the prosecutor's office. The motion was forwarded to the district court. However, Mr. McGuff did not appear for his October 24 court date. The hearing was then rescheduled for November 14, 2024, before Judge Cedric Simpson in the 14A1 District Court in Washtenaw County, Michigan, where Mr. McGuff again chose to represent himself.
The People versus Daniel McGuff.
Morning. Daniel McGuff.
You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongfully.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
okay, you haven't started out well.
Sorry. I'm here because I'm told to be here today, Your Honor. That's the only reason.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this: you want to represent yourself in this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you, if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you request an attorney represent you in this matter, the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
Judge Simpson explained to Mr. McGuff that he had the right to be represented by an attorney but also the right to represent himself. Under the Sixth Amendment, every criminal defendant has the right to legal counsel at all important stages of a case, including pretrial hearings such as a probable cause conference. This right includes having a court-appointed attorney at no cost if the defendant cannot afford one, as established by the Supreme Court in the 1963 case Gideon v. Wainwright. However, defendants may also choose to give up that right and act as their own lawyer. In Faretta v. California, 1975, the Supreme Court ruled that a defendant can represent themselves if they knowingly and voluntarily waive their right to counsel. Because of this, judges like Judge Simpson must make sure the defendant understands the risks and challenges of self-representation. If the defendant, such as Mr. McGuff, still chooses to proceed on their own, the judge must allow it.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained. And because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam?
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened, I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it. Your motion's denied.
Mr. McGuff filed a motion to suppress the body camera footage from his arrest, arguing that he was not read his Miranda rights before being detained. Judge Simpson denied the motion. A motion to suppress asks the court to exclude certain evidence because it was obtained in violation of the defendant's constitutional rights. In the 1966 Supreme Court case Miranda v. Arizona, the court ruled that statements made by a suspect during a custodial interrogation cannot be used in court unless the suspect was informed of their right to remain silent and their right to have an attorney present. However, the Miranda rule only applies when both custody and interrogation exist, meaning the suspect's freedom was significantly restricted and police were asking questions intended to produce incriminating responses. Routine questioning or brief detention before a formal arrest does not automatically require Miranda warnings. Even if Mr. McGuff was questioned without being read his rights, that would only affect the use of any statements he made, not the video itself. The Miranda rule protects against the use of forced or unwarned verbal statements, not against the admission of physical evidence such as video recordings. Therefore, while any unwarned comments made by Mr. McGuff could be redacted or excluded from the footage, the body camera video itself would still be admissible. For this reason, Judge Simpson correctly denied the motion to suppress. Maybe
I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there is full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. Nope.
Have you asked them, how do I get discovery?
No, I will be doing that.
You ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay. Well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do?
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. Then you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand. And that's the end goal of where I want to be one day. acquitted of all charges.
Your Honor, I don't mean to interrupt, but I am from the Public Defender's Office. I'd be happy if the court wanted to pass to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir, Your Honor?
All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
Maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process. Because otherwise, this thing could go go south for you.
Yeah, I understand.
Not be good. But I'll let you think about that. That's your call.
All right.
Court's in recess.
The court takes a short recess as Judge Simpson decides to hear other cases before recalling Mr. McGuff's case, giving him time to decide his next steps.